Hello folks, this is Kyle Graves. You can find my content at spacelawdigest.com. Today, I want to talk to you about patents in space. This is a longer piece. We're going to talk about a comprehensive overview of everything that I've researched so far regarding the landscape pertaining to patents in space, wrapping up this section before in future pieces we move on to a different topic. Again, this is Kyle Graves, spacelawdigest.com. Please subscribe to the podcast to continue receiving these updates. Now, this is a version of a presentation that I've given specifically for a particular client and modified for their context. If you have any interest in a custom presentation for you or for your context, or research into a particular issue that may pertain to your organization, why don't we chat? We're going to wrap up with patents in space and move on to a different space law topic. But this is a good capstone discussion to tie everything together and put it in a long form package for ongoing distribution. If you're on Spotify, you'll see that I have a slideshow that comes along with it. If you're not, if you're listening to the audio version, you'll receive all the same content. It's not necessary to view the slideshow to enjoy, digest, and appreciate today's topic. So let's continue. Patents in space. I'm going to go through a few things today. We're going to start with a background where we go through the basics of patent law. Then we're going to get into the problems specific to space and patents in space, the issue of territoriality, and then I want to move on to rules, particularly rules governing in-space activity for U.S. inventions. Move on to something practical. We'll talk about the recommendations today for innovators who have space-launched payloads or who have something that's involved in the space launching process, perhaps on the launch vehicle, and you're interested in maybe having some patent protection around that. Our fifth point will be to go into the theory of space governance more generally and how this might relate to future moves within the law in the U.S. and globally. And then finally, we'll look into the future direction that space law may head toward. Okay. Sharing now my screen. Here's what we just spoke about. The background, the problem, the rules, the practice, the theory of the future. Today's chat should be relatively comprehensive. Alright, folks. The basics of patent law. How should an inventor think about intellectual property? So, generally IP is an asset. You can use it to add value to the company. You can use it as collateral. You can license it. You can license it in many different ways as a revenue stream for your company. Now, IP can be an offensive tool. If you see others out there that are infringing your rights, you can put a stop to it. Or again, you can enter into a licensing discussion and generate alternative revenue streams. Then finally, it can be a defensive tool used to prevent legal action by others. You get in a situation where someone is asserting legal rights against you. Well, you can calm them down a little if you have your own patents that you can then assert against them. So as an inventor is thinking about the role of intellectual property in their company, really the main question that should be asked as we go through the discovery process, and I don't mean litigation discovery, I mean as an organization, you're trying to discover what role IP will play for you. The question to ask is, what are your business objectives? Many cases it will be licensing revenue, prep for an M&A activity, or for discussion with potential investor. In other instances, it will be protection from competitors who will see what you're doing and try to copy you. There's a lot of reasons you might pursue a strong IP portfolio. If you fail, however, to identify your objectives before you begin, you're not going to make the best use of your limited capital. Indeed, failure to identify your objectives is often the biggest problem in crafting an effective IP strategy. So what is a patent anyway? A patent is not a legal right, an affirmative set of permissions to do something. No. A patent is a right to exclude others from doing something, particularly to exclude others from making, using, or selling an invention. Now in the US, there's 3 requirements to be patentable. The invention has to be useful, the invention has to be novel, and it has to be non-obvious. Now these last 2 points, these are the ones that cause people the most trouble. Novelty means there's nothing in the literature indicating that it's been done before. Non-obviousness means there's nothing in the literature that, if combined with something else in the literature, works together collaboratively to make it so that this invention would have been apparent to a person having ordinary skill in the art reading these 2 references. Now this is the United States standard. Other countries apply a different set of terminology. In some places, you'll hear the term inventive step used. But in either instance, the rules are generally the same, and your patent rights protect against even innocent copying or otherwise legitimate reverse engineering. Now this is where patents are very important amongst honest technologists. Even innocent copying is grounds for a patent infringement lawsuit. So, let's be careful about the scope of our patents. Let's audit our business objectives and come up with a strategy to protect these space launch technologies that works for whatever you're planning to do in space, whether you're developing something to license to another or whether you are actively going to practice the invention yourself. Now, as I said, a patent is a right to exclude, not a right to use. And I have on the screen an example of how this works out in practice. Say, for instance, you have one company that's making stools. They're making a sitting device that has 4 vertically extending members, these are the legs, and a horizontal seat. It's a stool. Now say you have another company, it's making a chair. This is an improved sitting device with 4 vertically extending members, a horizontal seat, and a vertical back. Now, because patents are a right to exclude, both of these companies could have valid patent rights on their respective inventions. Correspondingly, the stool company could force the chair company to pay a licensing fee for every chair. Because what is a chair but a stool with a back? On the other hand, the chair company could block the stool people from expanding their product line. So as you see, you need to be very, very generous with your technologists in making available to them the pursuit of patent rights. Just because something seems to be not that big a deal to the technologist who invented it, it could in fact be a significant contribution to the art. Indeed, a lot of patents are incremental in nature. Someone who invented a chair while looking at a stool might say, it's not terribly inventive. But that's a call very often for the patent office that will surprise you and that will afford you opportunities to develop additional licensing revenue beyond just protecting your core business. Okay, so here's the problem with patents. Patents are geographically bound. Patents have their origin in local terrestrial law. Now, in the United States, our patent system goes all the way back to the Constitution. The Constitution, Article 1, Section 8, Clause 8, says that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Under this authority, Congress established the United States Patent and Trademark Office, or the USPTO, which administers our patent system. In the United States, inventions may be protected by patents if they satisfy two requirements. The invention is novel, the invention is non-obvious. We mentioned this earlier. Practically, this means that the government examiner will search the literature for the invention. If the examiner finds a single reference that teaches each aspect of the independent claim, the invention is not novel. If the examiner finds a combination of references, the invention is obvious. Now, there are specific rules about when you can combine references, but this is for the patent lawyers, and we needn't get into it today. Now, the paradox here is that patents only exclude others from copying your invention within a bounded territory. However, the USPTO can deny the grant of a patent based on a literature search worldwide. Now, this is not just in the United States. Many other countries with meaningful markets have very similar frameworks. Further, many of these countries, and indeed ours, in fact, over 180 such countries, are part of a treaty framework that allows you to take a pending patent application in one place or the other, and then use it to get in line in their own jurisdiction with corresponding patent rights, developing local patent applications based on that earlier one. Now, I've made a bit of a niche for myself harmonizing these international processes and practicing globally. It can get rather complicated, but the principles we talk about today are general enough to be applicable globally. Now, as we move into the space context, let's talk about some specific challenges. Now, where space launch technology gets really interesting is that some technologies are primarily used in space. Now, there's plenty of space launch technologies that can be adequately protected based on terrestrial traditional patent rights. For instance, there's technologies made on Earth, launched into space where they're used. Perhaps there's some way to protect it when it's sitting still on the Earth. Technologies that are made on Earth and used in a launch vehicle after which they're disposed. Again, these are more easily protectable based on the terrestrial framework. Technologies made on Earth that then return to Earth with a relaunchable vehicle. Again, quite a terrestrial nexus here. Technologies that are made in space and stay in space. Now we're getting a little bit iffy, breaking new territorial ground here. Technologies that are made in space and then return to Earth. That's a whole new ball of worms. I mean, you're inventing in space outside of any country. That's an entirely different question than the infringement question. That's also the question of invention. Let's go to a chart. If you're viewing along with me and not on an audio only version, in the slide that I'm showing, you can see various cases where an invention is made on Earth and then used in a space context. You'll see that protecting technologies used in the launch phase is rather trivial because a portion of the launch arguably occurs in a terrestrial junction, at least to the extent it's below the Kallman line. However, inventions which are primarily used in space present the interesting question of which territories patents and patent laws apply. Here in the second screen, you see another chart. The question of which territories' laws apply is doubly relevant for inventions that aren't just utilized in space, but, as shown on this slide, are made in space. So there are many use cases where you can use conventional territorial rights, terrestrial rights, to protect an invention. Conventional strategies rely on enforcement in the country where the space launch technology is made or launched. However, as more of the actual use occurs in space, reliance on infringement at the point of a commercial transaction, or at the point of manufacture, or at the point of simple possession and launch will become increasingly inadequate. The current best practice is very akin to enforcing rights to methods of medical treatment. You can't do it. But you can attack at the manufacturing stage or the commercial transaction stage. Remember, there's a lot of ways to infringe a patent. Buying, selling, offering for sale, making, using. However, remember the initial talk about patent claims and the requirement of novelty and non-obviousness? It's a lot easier to find novelty and non-obviousness in an invention when the invention is doing something more than just sitting there. So it's actually rather important to consider how to prepare your patents so that you can enforce them against activities that are actually happening in space, as a part to preparing a patent application with a variety of different claim scopes in it. However, even further, as more and more commercial activity happens in space, the availability of damages, the availability to obtain high ongoing licensing revenue, these types of things will hinge increasingly on the space side, on the space-based aspects, while you can prepare claims that are infringed terrestrially, as the ongoing licensing revenue generating and infringing activity is something occurring in space, it will become important and more important to get a grip on this idea of claiming space-based activity and then enforcement in space. To that end, I have two best practices on the screen. Strategy 1, consider bringing claims that pull the subject matter back to ground, such as method of manufacturing claims, or device claims that are infringed when the device is sitting in a hangar and doing nothing. However, we always want to future-proof our patent applications. A U.S. patent is good for 20 years, thereabout. So we want to have an eye towards claims that also are infringed primarily by something happening in space. Now, the rules for in-space activity have helpfully been provided in the U.S. under 35 U.S.C. Section 105. We find that for space-based activities, there is specific language defining which of those activities are within the jurisdictional territorial bounds of the United States for the purpose of patent enforcement. So, if an infringer's technology is doing certain things, the United States says, all right, our patent laws apply. Now, 35 U.S.C. says that for space inventions, if the vehicle thereupon is under the jurisdiction or the control of the United States, then those inventions are within the territory of the United States for the purpose of patent law. That's fine, but notice that key language, jurisdiction or control. These are quite loaded words. They do a whole lot of work, and they're clearly drafted in a context where much space activity was conducted by the arm of a sovereign state. So I want to present with this loaded language a bit of a difficult scenario. What if a company registered in the Bahamas with a launch vehicle above the Arctic Circle in Sweden and with outsourced mission control operated by a third party in Houston, launches a space vehicle. Is this under the jurisdiction or control of the United States? Well, I would argue that it is indeed, because the control facility is under the physical dominion of the United States. But say the vehicle has a Bahamian flag. I don't know. This falls within a gap in the statute. An agreement between the U.S. and the Bahamian Vehicle Registry is going to be needed, and such an agreement does not yet exist. Here is a potential issue as space and commercial value generation within space is increasingly privatized. So what are we going to do about this? We'll have a few takeaways. Now, as I mentioned about claiming strategies, consider presenting claims directed to a method of manufacturing. Consider presenting claims, device claims in particular, that are infringed when the device is sitting in a hangar doing nothing. Consider filing your applications in certain key jurisdictions to address this issue with the flag, with the launch facility, with the control facility. Specifically, consider protecting your rights in the launching jurisdiction, the manufacturing jurisdiction, your controlling jurisdiction, the jurisdiction where your customers are located, the jurisdiction where your competitors are located, and the jurisdiction of the flag registry, both for you and for your competitors. 1, 2, 3, 4, 5, 6, 7. That's a lot of jurisdictions, and that can be financially challenging. Once again, it's a great opportunity to begin with a PCT application and then move into national stage applications further down the road as you see revenue coming in and better appreciate the long-term coherence of the competitive landscape. Probably you'll want to protect your rights in the United States, the European Union, possibly under the Unified Patent, potentially China, potentially some of the former Soviet bloc states under the Unifying Treaty there. Some of the big space jurisdictions. There still yet remain some unanswered questions here. But if you do what we just spoke about, you'll do a pretty good job of securing your intellectual property rights associated with space launch technologies. Now, as space commercialization matures, these questions are going to get more complicated. So as always, it's very prudent to engage with competent counsel. In the United States, patents are good for 20 years. The commercial landscape is going to be very different 20 years from now. So we need to get ahead of these issues today. Okay, stepping on from the practical recommendations, why don't we explore current space governance? How is space governed today? How does that relate to IP? And what that might mean for us going forward as we move into that 20-year period that an existing patent may be good for. So we have not yet answered the question of what to do long-term going forward about protecting rights in space. We know that for U.S. flagged vehicles, U.S. patents protect because of 35 U.S.C. 105. We don't know about European Space Agency vehicles. I don't particularly have a clear answer for you. Everything is in flux. But let's walk through the treaty regime and see where things are headed. Space is governed by 5 basic treaties. The Outer Space Treaty of 1967 declares everything out there to be things common to all, international waters where there are no territorial sovereignty claims. This definition as international waters will come back and be important later. The Rescue Agreement of 1968, this is important. It governs cooperation in the rescue of space travelers. The Liability Convention of 1972 imposes liability on launching states for damages caused by space objects as they return to Earth. The Registration Convention of 1976. This was pretty important. It requires launching states to maintain a registry of objects. This is somewhat similar to what happens with ships, in that each flag nation has a registry of the vessels operating under that flag. We'll return to this topic later. The Moon Agreement of 1984. This expands the Outer Space Agreement of 67, but it's not signed by a lot of the key players. There's one space treaty relating to patents. This is the International Space Station Intergovernmental Agreement, the IGA of 1998. The IGA declares that IP invented in a module of the space station controlled by a particular country is deemed to have been invented in that country, with some complications for European-controlled modules. Specifically, the IGA provides that for the purposes of intellectual property law, an activity occurring in or on a space station flight element shall be deemed to have occurred only in the territory of the partner state of that element's registry, except for BSA registered elements, and there's some exceptions there for European partner states. So, the punchline is that the U.S. gives deference to the flag registry by federal regulation, and then the International Space Station is governed by a specific treaty, also referencing a flag registry. Flag registries are going to be important for space. So, you can see here at the outset, this is beginning to look a lot like maritime law. The flag of the vessel establishes the laws on board the vessel. So let's turn to maritime law and see what principles apply there. We have a lot of oil and gas inventions that are on the ocean. We have a lot of potential guidance that we can draw from that context for space. Indeed, we don't have a lot of laws for space, but we do have jurisprudence going back to the mid-1800s for the sea. So the sea can be divided into regions. Starting at the shore, the patent laws of the territory apply conventionally. One would presume that this would continue up to the Kálmán line, but again, we don't have a whole lot of boundary drawing because space launch vehicles will pass through the boundary conditions very quickly. Now, outside of the shore and the littoral waters, there's the territorial waters. This is more complicated, especially depending on how a nation handles exclusive economic zones. But as you move out into the territorial waters, different countries handle their rights differently. For example, in the UK, if you're on a ship flying under the flag of a Paris Convention country, and you're temporarily or accidentally in UK waters, then UK patent laws don't apply. A temporary infringing act is not grounds for an infringement lawsuit. Now, different countries don't have this. The US may handle this differently. So again, we're back into country-specific frameworks. There's no governing treaty that harmonizes this across the world. And we see the same thing in space, except for the ISS. We have no harmonizing treaty yet. Now, moving into international waters. Here, it's much harder to draw a nexus to a particular territory. But there are principles. A United States District Court held in 2016 that while on the high seas, a vessel is deemed to be a part of the territory to whose citizens it belongs and to under whose flag it sails. Now, that case was dismissed for lack of personal jurisdiction. Personal jurisdiction is usually state by state, and special rules kick in for foreign entities when you sue them in the United States. So this case went on appeal to the Federal Circuit, where the Federal Circuit held that there were sufficient minimum contacts with the relevant U.S. jurisdiction because the infringing technology was on a U.S. ship. So, for personal jurisdiction, at least as early as 2016, there was enough nexus to sue foreign entities infringing U.S. patents on a ship while that ship was flying a U.S. flag. The role of the U.S. flag on a vessel as a part of a patent lawsuit is well established. Even going back in the common law to 1856, an early patent infringement case found patent infringement on the high seas because the infringing thing occurred on a U.S. flagged vessel. Thus, we're seeing both in recent cases pertaining to personal jurisdiction and cases going all the way back to the 1800s that the flag tends to govern for U.S. patent infringement. This is a principle that may apply for space vehicles, but again, this is the U.S. context. Different countries may apply the rules differently for their own flag vehicles, and we have no harmonizing treaty unifying this approach. Now we're nearly done here. Let's move on and summarize some lessons from maritime law. Now, the flag of convenience still poses problems. No clear recommendation on enforcing patents against infringers flying flags of convenience exists. Perhaps try to capture their ground activity, but a flag of convenience in space will break new territorial ground with the jurisdiction issues and with the actual enforcement issues, and under which laws of which country do we begin to address the questions. So as I said before, claim strategies are try to bring things down to the ground with method of manufacturing claims or device claims that are infringed when the device is sitting in a hangar doing nothing. And then as far as jurisdictional strategies, consider filing applications in the launching jurisdiction, manufacturing jurisdiction, controlling jurisdiction, jurisdiction where customers are located, jurisdictions where competitors are doing the same things, and jurisdiction of the flag registry for you and your competitors. Now, let's talk about some next level ambiguities. Consider the challenge of multi-state enforcement. Consider you're out in space. There's a scientific vessel over here, a scientific vessel over here. These two vessels are both controlled by different countries, and they intend to dock and collaborate in some way for a peaceful scientific endeavor. Now, suppose there's a complicated docking mechanism on the vessels, so that as they dock, they connect together, trade materials and people, and separate and go on their way. Now, suppose there are patents covering pieces of this docking mechanism, and some claims of the patent have elements performed by one space vehicle and another space vehicle. In the terrestrial sphere, we have something called divided infringement, where infringement can be found when two actors operate in concert to perform the elements of a patent claim. As we know, though, patents are territorial in nature, so while we may have divided infringement among the two vehicles, the jurisdiction is also divided, with one part flying under one flag and one part flying under another flag. So what happens when we have divided infringement across jurisdiction? I don't know. The law doesn't know. The courts don't know. We don't have treaties setting this out. This is going to be a new frontier for space law. However, if you will engage with the process we've talked about today, where you identify your business projections, figure out the places where you think your technology is going, you identify your business objectives, figure out what you want to do with these patents anyway, and then knowing that, decide on territories that are strongly associated with you, your competitors, and the customers of each. Then add onto that conventional analysis also territories associated with the flag registry and territories associated with the flag registry that your competitors may be involved with. Then you stand a pretty good chance of protecting your space-launched inventions. Alright folks, well I hope you've enjoyed this series on space law, particularly space law and patents. I'm wrapping it up now. This is Kyle Graves at spacelawdigest.com. and we'll move on to a new topic soon. Thank you.